Sí, no?
Sí, jo crec que...
Hello? Yes. Així és el correcte? La distància? Hola, bon dia a tothom. Bonjour. Good morning. Guten Morgen. Buongiorno. So it's a pleasure to have all of you here and welcome to this panel organized by the Catalan Data Protection Authority. My name is Olga Rierola. I am responsible for cooperation and training programs in the Catalan Data Protection Authority. Today, we want to highlight the role of the DPO and debate the new challenge brought about the implementation of the new rules of the game in the European digital sphere that directly impact data protection, like the AI Act, the Data Act, Digital Markets Act, and Digital Service Act. At the Catalan Data Protection Authority, we have always shown a firm commitment to the figure of the DPO as a key actor in the defense of data protection rights within organizations. In fact, one of the main objectives of our strategic plan is to provide support to DPOs. And in this regard, our director, Meritxell Borràs, who is here today with us, has committed to a range of actions. One of the main ones has been the creation of DPD en xarxa, that is the Catalan DPO network, in 2023, the first DPOs learning and collaboration network in Catalonia and in the Spanish state, which has served as a reference for similar subsequent initiatives. Through this network, continuous training is promoted via webinars, discussion is fostered around specific thematic, working groups, and the creation of synergies is encouraged to draw on the expertise of the professionals who participate. All of this in order to continue growing in the defense of data protection, to remain permanently up to date, as we said, it's very important with all these new regulations, and to work together on the new challenges that arise day by day. So now let's focus in our panel today, framed in the DPO's track. First of all, allow me to make a brief reference to the European digital strategy around the data economy, as I think it's important to set the foundation for this panel. In recent years, we have seen how technology has enabled an increasingly deep, complex, and massive processing of data. At the same time, every day, we generate an infinite amount of data that is analyzed by these technologies. This analysis is giving that data even greater economic values. And as a result, many companies have long been trading in data and deriving profit from it. And it's no secret that personal data is enormously valued in economic terms, and that the risk of profiling individuals are very significant, potentially revealing not only their economic profile, but also their social or ideological one. Faced with this reality, as we all know, the European Union adopted 10 years ago the GDPR, and since then, a set of new digital rules, which are the protagonists today, that interact with the GDPR because they have data, both personal and non-personal, as the basis for generating value, both public and private. And it is in this interconnection that DPOs play a key role in defining where data protection law applies and where it does not. That is, when we are and when we are not dealing with the processing of personal data. In short, the GDPR regulates how personal data may be processed, and all the other regulations must draw on the principles and obligations of the GDPR. In this regard, as we said, we now have regulations such as the Data Act, the Data Governance Act, AI Act, and Digital Markets Act. And to give an example, the AI Act is a product regulation, as we all know, not a rights regulation. And therefore, if personal data is being processed, the GDPR always comes first. But if the DPO has no idea how AI works, they will not be able to advise correctly. Ultimately, the DPO is part of the organization. They are not a supervisory authority. So they are a compliance support function within their organization with a very important role, as we know, protecting people's rights. So to finish, this introduction, let me say again that what is important to understand is that when we talk about the data economy, we are very often also talking about personal data. And that is why all the regulations I have referenced before refer at some point to the GDPR and its centrality. GDPR is first, because human beings are first, fundamental rights are first. In a world shaped by artificial intelligence, platform economies, and increasing data-driven innovation, the GDPR ensures that technological progress goes hand in hand in the protection of individual rights. So, without further ado, I would like to introduce you today our fantastic panel composed by 2 DPOs representatives, so Esther and Emese, and 2 DPS representatives, which will enrich our debate, I'm sure. So, on my left, I have Esther Garcia. She's head of the Privacy and AI Office at CaixaBank, a leading financial institution in our country, developing functions within the Data Protection Officer Department. She currently oversees privacy program and AI governance initiatives that are being developed in order to implement AI Act, with a strong focus on the design of AI risk and fundamental rights impact assessment frameworks. So let me introduce our other DPO representative here in our panel. She's Emese Saboya-Keliti. She's the Data Protection Officer of the European External Action Service. Some of you will know here. She has over 15 years experience in data protection dealing with privacy and processing personal data in EU institutions and bodies. Hello, Emese. And now, from the DPS representatives, we have Dr. Marit Hansen, who is the State Data Protection Commissioner of Schleswig-Holstein and Chief of Unabhängiges Landeszentrum für Datenschutz Science 2015. Thank you. And then, so at least but not last, sorry, it was an opposite. And last but not least, my nervous, sorry. We have Daniel Enarde. He's the Legal Service Officer at the European Data Protection Supervisor, where he coordinates litigation and interinstitutional and other horizontal matters. Thank you very much to all of you for accepting our invitation in this panel. So now, first, we will address to Esther, so to open the discussion. So Esther, as we say, you have been involved with the topic of DPOs and privacy professionals for a very long time. So I wanted to ask you, 10 years after the GDPR came into application, could you share your views of how has the role of DPOs evolved in the last 10 years, and which are, in your point of view, the main reasons of the evolution of DPO's role? So how and why? Mm-hmm. Thank you.
Thank you, Olga, for the question. And before I begin, I would like to thank the Catalan Data Protection Authority for the opportunity to participate in this panel. In particular, my thanks to its director, Meritxell Borràs, to its DPO, Joana Maria, and of course to our moderator, Olga Rierola, for making this discussion possible. It is a real pleasure for me to be here today. So regarding your question, Olga, mm-hmm. Yes, I think I do think the role of the DPO has really evolved in the last 10 years, and I would like to talk to you and why this role has evolved, and then we will go to how has it evolved. I think there are 2 main reasons why the role of DPOs evolved. The first one, I would say, is the evolution of the technical reality in which DPOs always carry out our job. And the second one, of course, are these new pieces of regulations that Olga mentioned. And I would add here that, of course, GDPR evolution, its interpretation and application itself has had also a very relevant impact in our role. If regarding the first reason I mentioned, technological reality we live in, what do I mean? No? The reality we operate in is changing so quickly and becomes more and more complex every day. For example, a few years ago, we were all focused on understanding blockchain. And then our attention moved to supply chains. And now, more recently, we are all seeing this boom of artificial intelligence, an area that continues surprising us on a daily basis, I would say. The fact here, for me, I think that there are a lot of technological developments and new operational realities, and because of this, for DPOs, it's very difficult to keep fully up to date. And for me, I would like to point out here a very practical implication of this, because this complex reality directly affects how organizations process data. And this means constant changes. For example, in assets through which data flows, or suppliers we have involved in our activities. So this creates a very relevant challenge in a very specific key of our compliance model, which is maintaining an accurate and up-to-date record of processing of activities. Regarding the second reason I mentioned, both the evolution of interpretation of GDPR and I would like to stop here a moment before going into the new pieces of regulations. Of course, all we know that since its entry into force, the interpretation of GDPR has continually evolved, of course, through the decisions and guidance issued by data protection authorities, ruling from both national and European courts, of course, also from opinions or guidelines from European Data Protection Board and European Data Protection Supervisor. So, as the audience is well aware, even now, 10 years after its entry into force, we continue to face a very practical challenges such as determining when data are truly anonymous or not.
Sorry,
and whether,
to interrupt you, I will take later about this point with Daniela Nari. Yes, thank you.
Thank you. And whether and under what conditions, for example, biometric data processing activities are possible or not. Regarding the new pieces of regulations, of course, the activity in this field the last years has been very, very intensive. And from my side in the financial sector, I can point out two regulations that have a very significant impact, and I would say that are having still a very significant impact, which are, of course, Artificial Intelligence Act and DORA. Here, the fact, again, is the same. Here, keeping pace with both the evolving interpretation of GDPR and this adoption of new laws is really challenging in practice. And here, the key implication I would like to share with you is that for DPOs, in my opinion, is not just compliance, but governance. And why? Because new interpretations might trigger the need to revisit existing impact assessment or resist legal basis, for example. And in the case of new laws, such the Artificial Intelligence Act, new laws will require from organizations to adjust, design, or redesign processes to keep everything aligned and coherent. So here we need a very strong governance to manage these impacts. And if we focus on how's our role evolved under our perspective, I think in the past, under directive and national laws, we operate under a formal compliance model. We use to have checklist-based approach, very focused on specific security measures. Today, DPOs needs to go beyond formal compliance. Organizational technical measures are no longer closed lists. Instead, they are open frameworks tailored to each organization. The risk associated with data processing activities are increasing, are diversifying, and are becoming more sophisticated. Overlapping regulations make it very difficult to create practical and sustainable processes. And I would say also that the asset we protect evolve also. We change our focus from protecting one fundamental right, data protection, to the protection of all fundamental rights. And in practical terms, I would say that this requires DPOs to rethink their governance models. Governance must remain effective, but also agile enough to keep pace with both this fast-changing technological environment and this more complex regulatory landscape.
Thank you very much, Esther, for this detailed explanation. Perhaps we'll come later with how do DPOs feel. Okay. Now I would like to introduce to make a question to a message. So after we heard Esther, I would like to ask you, so in your case, with your large experience as a DPO in the context of EUA institution, so Esther, could you tell us which of these new EU digital regulation most directly impact your day-to-day work? So, and in your point of view, it will be the second question about how DPOs feel with this new situation of broader mandate. The floor is yours.
Thanks very much. And indeed, we are 10 years after GDPR, as Esther mentioned, and in my little notes, I said it seems that Europe's digital transformation is now reshaping our roles, but I think it's not actually seems, it is the reality. I would like to ask the colleagues to put the slide on that. I love colors and then the visualization. The panel before, I made a short intervention as DPO, emphasizing that the awareness raising is so important. And I do this with some presentations to my staff as well at the DP days. But in any case, why we are here today is to talk about the impacts of these digital acts and the reshaping, as I mentioned, the confirmed reshaping of our role. I put all these acts. We don't need to read this out. Data Act, DMA, DSA. I added the Cybersecurity Act, of course, and the Act as well. And they are not just adding to our workload in a way, but they are kind of redefining what it means to be a DPO, basically a data protection professional. And they are also adding new responsibilities. Of course, it doesn't mean that we have to put our nose into everything and that we have to have an opinion on anything that is data related. Sometimes data sets may not have personal data, but in many cases they do. And it actually does also mean that we shouldn't be barriers to this innovation, and to all these digital acts are obviously pointing to the digital innovation, and we shouldn't stop technology, obviously. So what organizations expect from the DPOs in this evolving role, let's say, and what exactly our role is indeed a critical question. And thanks very much for the Catalan DP and Marichel, as well as Oana and Olga for inviting me and hosting this discussion. I had the pleasure to already participate at one of your DPO networks meetings as well. So what are we talking about? This expanding role, and you see my slide with a little bit of holding our heads as DPOs. What is missing there is the GDPR. I thought about this, but at the same time, DPOs are kind of identified now with the GDPR. So our main role, so long before when I started in 2009 at the Commission, so in EU institutions as a DPC, Data Protection Coordinator, and then moving on as of 2012 in the ES, I primarily focused on the GDPR. But these days are somehow gone, and now today we are faced with all these interconnected regulations. And yes, we have a bit of more say-so, I would say, to influence these decisions beyond privacy as well. And we are definitely consulted in many areas. So my opinion is requested now for AI, cybersecurity, digital services. And you have asked, Olga, what is the biggest impact? So I thought that maybe I just bring then 3 examples or 3 areas. So if we go on, I guess I can. One would be this maybe we can move on already. The AI Act, of course. So it's I will speak a little bit about the AI Act, the Cybersecurity Act, and the Digital Service Act. Not in details and not what they are about, but what it actually means for us a bit. And we cannot not talk about the AI Act. Esther also mentioned it. And AI Act, in a way, is a bit of a game changer for us, DPOs, but for all of us, for me as a citizen, for me as a mother, to understand my kids. We should obviously embrace that. We heard this before. So let's take an example, and I know that the DPS is working on a great project with the Commission on a sandbox project, let's say. But what it is about is an AI-driven HR tool for screening CVs. I thought this example is relevant because most of our organizations will face that maybe we have a lot of applications, and then HR department is overwhelmed, and then they come and run to us and say, we have this wonderful AI tool, and we will just screen the CVs, and what do you think, Emese? So what I think is that we have to check and audit the training data, and we have to look at obviously special categories of data, race, ethnic origin, political beliefs, whatever that could be in a CV. We have to assess the risks, and in addition, we obviously have to ensure the core business of ours, so the data protection records and data processing records and the privacy statements or data protection notices. So in my daily work, as you asked, I really feel the effect and a bit of pressure of being or having a good grasp of the AI Act. In particular, that I'm also the so-called AI correspondent for the ES vis-a-vis the European Data Protection Supervisor, who is the market surveillance authority for EU institutions, let's say, so the AI supervisory authority for us EU institutions, bodies, and offices, agencies. So we have to be a bit on top of this file, and I'm trying to upskill my competencies. But AI literacy, as we know, is also something that we have to enforce. But to understand the AI models, the algorithmic transparency, and all this is it's just something new, and we continuously have to learn. If we move on to cybersecurity, a bit similar. Of course, cybersecurity and AI has been there for us as well, but with the AI Act, of course, this is a little bit more enforced. But with cybersecurity, the DPO has been obviously consulted. Nevertheless, we have the new proposal from the Commission on the Cybersecurity Act and the whole NIS2 for member states. So for any cybersecurity incident, even before we know that there is personal data involved, colleagues come to me, MSM, maybe there is something we need to be aware and make the documentation. So these standards also the cybersecurity standards also influence DPA compliance. The DPAs may use these NIS2 benchmarks and assess GDPR's integrity and confidentiality. The DPOs must check the Cybersecurity Act certified cloud providers. We need to meet the GDPR obligations on data flows, purpose limitation, data subject rights, obviously. And again, I'm coming back to the awareness raising. So security awareness is really paramount among staff. And we see as well that data subjects, so citizens, not only internal but external persons, individuals, are really aware now, and they come and see and ask questions. So to communicate to data subject is something vital. We really have this issue that, according to the regulation, we only communicate when there is a high risk. But this balance is difficult. Usually I try to advise my colleagues, and I know sometimes the answer that we don't want to create panic. But at the same time, for the data subjects, for the individuals to be aware of those incidents and to prepare them and maybe avoid something even more risky for their personal data is something that is really important. So we also notify the supervisory authority. I mean, we act on behalf of the data controller, and yeah, this is just another layer, just as the Digital Service Act. And I just wanted to point out one example about the websites, because I think that all organizations are now very concerned. We have our website. This is information. This is also awareness raising and providing values. And nowadays, because of DCA, and of course this is very welcome shift, that there are stricter rules on the cookies, on the transparency, and then the content moderation, let's say. And the EU institutions are not exceptions. We don't have advertising, but we have promoting our activities. So I do believe that this is something that we have to be aware, that this multi-related environment, because of all these acts, and I just brought some examples. And then if we move forward, you also asked the questions about how we feel and how we not only feel, but how we actually tend to progress and embrace. So yeah, indeed, there is a bit of a pressure, as I mentioned, but at the same time, we I think understand that this upskilling, so learning about the AI Act, learning more about cybersecurity. Now I am really proud. I have a daughter who is now at the first year of legal studies, and she already had a traineeship, and cybersecurity was mentioned, and said, "Oh, but mom, this is something really, really interesting, and I might be interested." And I said, "Go for it." I think this is something really progressing, and not only AI Act, because AI, of course, is with us, but at the same time, I think these new responsibilities are giving us a bit of more influence, a bit of more power, and we possibly welcome this, because obviously DPOs value that our opinion is and our voice is heard. But there is this apprehension that are we prepared? Do we know a lot about algorithms, about the cybersecurity background? And yeah, we have to deal with this, but I think we will address this question
Yes.
at the next level, so I will stop here.
Perfect.
And I just finish with this last slide. You have seen the head who, when I said that there is an apprehension, so that's my future, my bright future slide. I try to be always positive and communicate this to my colleagues as well, so I think a smiling face is needed here, and to try to be on the top of the fight.
Thank you, Messe, for giving us such detailed examples of cross-regulatory situations and about the expanding role of DPO, and as finally about this point of view of how do DPOs feel in this new UEA regulatory landscape. So before going to Daniele, just please, because about how do DPOs feel in this new situation, let me just ask Esther about that point as well, because it's good to know both point of views of DPOs. Thank you very much.
Yes, thank you, Olga. Yes, I would like to address this point, if you let me, referring first to what studies across Spain and Europe tell us about what or how do DPOs feel, and then I will share with you briefly how we feel actually. So the first thing that appear in studies is pressure, and Messe mentioned it, and this is due to things like increasing complexity of data protection activities, increase of regulatory expectations, the expansion of the role itself. We already have seen it in these slides. Second thing the studies report is that DPOs feel overstretched. We feel all overstretched. What do I mean by that? Limited resources, lack of time to advise, to monitor, And difficulty, of course, of keeping up with ongoing regulatory and technological developments. Thirdly, and regarding independence and position, and I think we will talk about this later on, the picture is mixed. While many DPOs feel they are consulted, others reported limited participation, difficulties for accessing senior management, and of course this can lead to frustration, especially when DPOs we are involved too late. In our case, how do we feel? We feel, of course, under significant, a very relevant pressure. We need to stay, as everybody else, up to date legally and technically, and this is highly challenging. And on the top of that, I would add that the current context is requiring us to invest time and resources in exploring how artificial intelligence can support our work. So at the moment, we are constantly balancing two priorities, keeping up and innovating. And of course, at the same time, we feel excited, of course, about the moment we live in, the role we are playing. And as I mentioned, I think it's very important that our focus of protection evolve. And but this means protecting all fundamental rights means a greater challenge and a greater responsibility. And here, for me, the question is, are all we DPOs ready to make that journey from being DPOs to being fundamental rights officers? I don't know, Olga, perhaps we can do a survey with the audience.
Perhaps later, when we have the question and answers time, you can introduce your thoughts about that. Thank you very much, Esther. So now we will address to the DPS representatives. So in the first place, Daniel Nardi, please. So now we have already had DPO's point of view about this, how do they feel about this evolving role and what does it mean for them day to day. So from your point of view, which are the main challenges and difficulties for DPOs nowadays in the EU data landscape? And we should add about that DPOs, we have new laws that keep adding functions to the DPO, and they have to integrate new EU laws in their day-to-day work. But do you think that this can arise a conflict of interest and affect DPO's independence, as Esther introduced as well?
Thank you, Olga, and also from my side and from the EDPS, warm thanks to the Catalan Data Protection Authority for this invitation to speak about something which I think is very important, and I will address a bit immediately your point. Before, I was curious to know in the audience, how many of you, if you want to raise your hand, how many of you are DPOs? So we have a very good representation. How many of you are also having other roles, be it in the legal service or AI Act correspondent, DMA? Okay. So some of you do have various roles, and this brings me a bit to the very nice slides that Emeze presented before, where we had the DPO holding his head and not looking very happy, right? I think there are indeed many challenges. Many new legal acts have added roles, formally or informally, probably more informally, but for your workload, this doesn't change. You have, and I loved also the expression which was in the Mesa slide, sometimes accountability without authority. So it seems that Mesa was really right in having the first slide with the DPO holding the hands. And now I also get the question from Olga, what about conflict of interest? So you guys also have to cope with conflict of interest. Well, when I was thinking about this question, are DPOs are in a risk of managing difficult conflict of interest because of all these roles, because of these acts? And I see heads nodding, and I understand, but I would say, let's take a step back. Conflict of interest may certainly arise, especially given this huge constellation of legislation that you have to cope with, that your hierarchy, your administration is telling you to do, cybersecurity, DMA, DSA, and Artificial Intelligence Act. All of this is very simple, right? But now we have guidance, at least some guidance from the court, and working in a legal service and having a bit of more horizontal function, I love to go back to the court. And the European Court of Justice issued in 2023 the XFAB ruling, specifically on the notion of conflict of interest. Now, we know that a DPO cannot have tasks which would transform him or her in a data controller. And I think this is an extreme synthesis, the lesson we can draw from the XFAB ruling. Why this? Because DPO are independent, and independence needs a certain detachment. You cannot be involved in the choices about the data processing. You cannot be involved in the determination of the purposes and means of the processing. And in this, the role of DPO is perhaps similar to the role of central legal services. And I think that, yes, you probably are still keeping your head, but I want to see also an opportunity working in my practice with issues that range from data protection, human resources, litigation, and having a bit of a horizontal portfolio by definition. I would say that this is also an opportunity for you, especially if you consider that if we go back to this issue of conflict of interest, are you in a conflict of interest situation, yes or no? Well, you need to assess this case by case. Another lesson from the ruling of the Court of Justice, from the XFAB ruling. And for example, if you have to deal with AI, of course, a lot will depend on the circumstances. Are we talking about a company developing actively AI, or are you in charge of the supervision of the use that your company or your institution makes of AI? This distinction might be not always clear, but bear with me for the time being. For example, if you are named the Chief AI Officer, this would imply that probably you have a very proactive role, which might not be compatible with the impartiality that you need to have as a DPO. I believe, however, that the criterion to apply remain whether what you are called to do, what you are called to perform as additional tasks, influence or not your independent monitoring of the GDPR obligation. This might sound theoretical, but I will try to make it a bit more concrete. If a DPO is charged with promoting the uptake of AI in a compliant way, well, I think we are really in the slides that Emese was mentioning, and also we are really back to what Esther was mentioning about being a governance job. You're going to have a governance job, you're becoming much more a strategic advisor. Indeed, the job of DPO is getting closer to that of legal services or central legal unit. But this task of just promoting the uptake probably will not necessarily be creating a conflict of interest. Actually, I would like to see in it also the possibility for the DPO to become really a strategic advisor and say, look, this can be done in a compliant way. This adds to your homeworks because you have to be conversant with AI Act, with many other legal, not very simple pieces of legislation. But I want to see in this also an opportunity for growth, personal growth and growth of your company in a way, in improving not just compliance, but indeed overall governance. In the end, I believe that the DPO must remain the guardian of compliance with the GDPR. But as long as that role is preserved, the addition of other roles from a purely legal perspective is not in itself creative, is not in itself conducive to a conflict of interest. Of course, and we were mentioning this before the panel this morning with Esther, you need resources. Because, of course, if you need to be conversant in cybersecurity, in digital markets and therefore competition, it's a bit of a challenge. So with the governance, with increased governance role that you have, you need to have the equivalent resources, which is not always easy. So there is a path of personal improvement that you can take, but of course you can go up to a point before becoming an Indian goddess with many arms. So I would conclude perhaps here. I'm afraid I cannot give you more answers. Of course, money doesn't solve all problems, but it certainly tries hard, right?
Oh, thank you. Fantastic for your explanation and just so practice about this so legal concept. So now let me address to Marit Hansen. So as we say, the advent of the EU digital rulebook means not only that there are several new regulatory intersections that need to be navigated, but also that there are quite a few new supervisory authorities. So from your point of view, how can DPO face this new challenge by a growing and complex digital regulatory landscape and the rapid development in technology? How should it be managed by DPOs? And all these cross-cutting requirements and obligations that they have to face. This will be the first, and then from how could DPS help DPOs in all these challenges?
I think it belongs together. Thank you very much for the invitation to my colleague. Your name is even more beautiful than my name. Merit only, but Merit Shell is of course much better. No, thank you very much. And I've just come from a Berlin conference with many DPOs, and in Germany we have a huge DPO tradition. So even tiny companies need a DPO, not only the bigger ones, so 250 or more people dealing with personal data. And therefore, there are many associations dealing already with the common interests and having own conferences and discussing with DPAs and among each other. And I think one answer is the culture, the totally different answer now, because what I learned, and yesterday, for example, the DPO from Adidas told the DPOs she meets, they all understand both law and technology to a sufficient extent. So you already know something in both areas, and probably also organization and how to communicate. I think this is very, very important, perhaps underestimated. And then that it's not so hard to learn the new stuff. Of course, it's limited, and you should also be able to talk to experts. And if I say you're at the forefront as DPOs, the same, of course, holds for DPAs. We also have to gain the knowledge, and sometimes we feel like the person's wanting to only cry because of everything which is happening. But the DPOs, and also I think the DPAs, they are the best people right now, the best and at the best positions to, well, hold strongly the fundamental rights. And I think this is not a huge change to having the perspective of all fundamental rights. If you look into Article 35, the data protection, data impact assessment, DPIA, then it's not only about data protection rights, it's fundamental rights, it's risks to the rights and freedoms of human beings. So, and therefore, in principle, you know that already. Of course, now that I cannot lull you into something you know already, that it's not right. It's happening so much. Of course, we can be overwhelmed, and sometimes it's also something where we have a good solution from the DPA or DPO perspective, and still it does not work with the other legal obligations and the other way around, because there might be, again, different alternatives which combine all mandatory regulatory requirements. So sometimes one solution is not enough. It has to be the solution or one of those solutions combining the requirements. And I think we cannot have everything in our heads, especially if we want to go the way fundamental rights and we are not the decision makers. Even the DPAs are not the decision makers then in the companies. This then has to be clarified before court. But the DPOs can really, well, not relax so much, but saying, I made my point. I'm the one here for the fundamental rights. I know the stuff, and I have the direct line to the DPA. So in Germany, it works quite well. Sometimes we are approached very often directly by DPOs. Sometimes we have own events inviting them or have own mailing lists. Also, where there are parts of meetings where we are excluded or want to be excluded, so that they can be more open. But also that we have some formats like I'm asking for a friend. So they come and join and don't tell it's about themselves. Sometimes it is, sometimes it's not, I don't know. But that it's clear that there's a trustworthy possibility to exchange and also say, I really think it's not okay, what can we do? And that we find a solution. So I think we are all overwhelmed. Any citizen, meanwhile, is overwhelmed. But we are in the best situation, having the best knowledge right now, because we have all been trained to look a little bit ahead, have been trained in fundamental rights, and have the culture of communicating. So I'm believing in you as DPOs and us as DPAs. Thank you very much.
Thank you very much. So about, as we said, DPS as warrant of fundamental rights, DPOs as warrants of fundamental rights, and about the supervision fragmentation problem, about, as we have all these different authorities which has something to say, how do you approach to this problem, this situation in your DPA?
We should lead by example. So meaning we are in Germany, it's different than in the European or the European level than in other countries. Who is responsible for what? The Data Act or the political targeting, and there's much more. And therefore, we need to approach those who are doing sometimes it's a product checking, sometimes it's also some process governance, to make sure that we come to the same conclusion, that everything is really integrated. And therefore, we are offering a dialogue from the DPA perspective with all. It's sometimes a little bit difficult because Germany is a little bit behind to apply and make sure that there are all institutions now in place. And it's handled differently in all member states. I think this is not so good because we want European collaboration and everybody has different knowledge, but perhaps this is now the first year that we see the interplays being defined, and then it's getting better. But it wouldn't make sense to have perhaps advice for one solution which is not lawful in other areas. We've seen that in the past with, for example, age verification. Some age verification tools were not legally compliant, but still they were advertised by our media control authorities. But it's sometimes there are difficulties. We have to make sure that this happens, that it's avoided as much as possible, and that we find solutions if we find out that there are these failures. But of course, the alternative, putting all digital things, all data things into one authority, probably it wouldn't work either. So let's deal with it as we have it now. Communication is key. We heard it already. I think we need that, and therefore we have to approach. And if you ask as DPOs, you DPAs, and they are lost, then it's no shame to be lost together with them. No, I think we are all discussing then that nobody gets lost. Thank you.
Thank you very much, Marit. So it's not easy, and to hear about all your experience. It's very useful for all DPAs. Thank you very much. So, and going back to the day-to-day and with this overlapping situation, I will, Esther, just address to you, if you could just tell us 2 examples of your how overlapping regulation can become a practical challenge for organizations. So, and how do you see the risk of conflicts of interest when new responsibilities are added to the DPO's role? I know that Daniele made our explanation, but in a practical way. So, yes, quite quick because we're beginning to be short of time. Thank you very much.
Okay, all right. So I will share with you 1 or 2 examples. Let me know about the time. The first example I would like to share with you, and I think all in the audience we are aware, is the interplay between Article 35 of GDPR and Article 27 of Artificial Intelligence Act. As we all know, Article 35 of GDPR will require data protection impact assessment when processing is likely to result in a higher risk for rights and freedoms, as Mary said. Of course, Article 27 of Artificial Intelligence Act introduced an obligations to perform fundamental rights impact assessment for certain high-risk AI systems. This, of course, creates a few challenges. First of all, there is a risk of duplication of efforts in organizations, and there may be a difference in scope, methodologies, timing, teams, many things. So it's true, of course, that AI recognize these overlaps and allow for coordinations, and fundamental rights impact assessment should complement the data protection impact assessment rather than duplicate it. However, in my opinion, in practice, the challenge remains. Organizations still need to determine how to align both assessments. And in this context, I would like to share with you an ongoing initiative. We are working in a group created under the DPOs and Xarxa, as Olga mentioned, promoted by Catalan Data Protection Authority and led by Professor Alessandro Mantelero. In January 2025, the group published a methodology for conducting these fundamental rights impact assessments, which later was recognized by European Union Agency for Fundamental Rights as a useful tool. So we are very happy for that, and of course, if anyone in the audience is interested in the model and the methodology, both of them are available for download on the website of the Catalan Data Protection Authority. What is our current focus? We are working on developing a coherent approach to integrate these two exercises. And this would include, between others, clarifying the respective objectives, identifying the obligation of doing one another when every article applies, and of course, aligning their scope in a very practical and operational way. So that was my first example. Olga, let me know if you want to go to the other.
No, perhaps to the question about the conflict of interest, because it was fantastic to know about this intersection of fundamental rights impact assessment, data protection impact assessment, that we are all really worried about how to interplay, how to intersect, and know about the conflict of interest, please.
Yes, of course. Going to the point touched by Daniele, I think in my perspective and in a very practical way, I totally agree with Daniele. I think we need to go case by case in order to see where we draw the line. And for me, it's clear what the Court of Justice says, and several data protection authorities also have said that we can DPOs cannot go into deciding the why and the how in a data processing activity, because that could raise the conflict of interest. So if I go into a practical example in the context of artificial intelligence, and taking what Daniel mentioned, for example, defining an organization AI strategy, such as choosing platforms to be used, or models to be deployed, or what to outsource or not. That, in my opinion, involves decisions about the means of processing, and that could raise, of course, conflict of interest. By contrast, advising in a legal way about AI Act, for example, contributing to the risk management system, or leading fundamental rights impact assessment, in my opinion, would be fully aligned with the DPO's advisory role. And in fact, I would like to add here that not assigning these functions to the DPO could lead even to more fragmentation and less coherence when you are working in a daily basis in an organization.
Okay, thank you very much. Daniela, I don't know if you want to add something about this conflict of interest vision, or it was...
No, I think we are fully in line. Maybe what I was thinking while listening to Esther is that in the example in which you are called as a DPO, to choose between different AI tools, for example. Well, if you are the one choosing, yes, I would agree that there is a problem. But if you are the one who is called to advise about which one presents less compliance risks, of course, that I would claim is really your role, and there you have a duty to advise in that sense, to indicate what would be the most compliant solution. And then independence implies a certain separation. The responsibility is taken by the CEO, the hierarchy in the company, to balance the risks that you have highlighted. But that's the crucial role, to highlight where are the risks, the compliance risks, the problems, the red lines in case it's necessary. And that is something that it cannot create a conflict of interest. Otherwise, and that was never the intention of the legislator, those pieces of legislation could not really live together in real life. Now, we can have many complaints and many criticisms as to how the legislator organized the living together of these many pieces of legislation. But one thing is for sure, is that they have to work together, and when they will lead the court will make it in such a way that they will work together in some way or another. So your role is to anticipate what the court would do, taking into account, of course, the fact that you are not independent as a judge. You have a functional independence, and you work for your company. So your role is for your institution as well. Your role is to solve problems.
Perfect. Thank you very much, Daniele. So now we have to be quite quick because there still remain 3 questions to our panelists, and then we have to have some time for the question and answer. So a message, as if it's possible in 3 minutes. So let me ask you about, from in your point of view, about what do you think about the increase every responsibility of DPOs. What do you think about that? So, and what organizational conditions do you think that are needed to enable DPOs to take on those?
Thanks very much, Olga. And you are lucky because I have 3 slides, so 3 minutes.
Perfect.
I hope that the colleagues will put it also on now. And indeed, I prepared a little bit more of an introductory to this part of the. It's slide number 8, please. And yeah, that was the positive picture. And then if we move on to the next one, yeah, I can move on.
It's negative again?
No, not negative. It's just the overwhelming landscape is still there. And I loved your last word was, your role is to solve problems. I do feel as a problem solver, and I actually wanted to ask, also raise hands, how many DPOs, but you possibly feel that as well. So a little bit about the overwhelmingness. I know it's not really a word, but yeah, so I talked about the AI Act, I talked about the cybersecurity. So all these topics are adding and giving us new responsibilities and trying to feel the pressure that we have to upskill ourselves. I wanted to bring a very short example about the DCA. We talked less about the Digital Market Act, Digital Service Act. I mentioned the example about the website. So a very banal example, we just had an erasure request. So under our EU DPR, so GDPR equivalent for EU institutions, Article 19, okay, very simple. There was a young fellow, military related with missions. I wanted to erase the article about him, which was totally positive with nice pictures. But all of a sudden he thought, well, I don't want this anymore. Whatever reason, we cannot ask, we do not ask. So that is fine. That's the GDPR part. But then I was facing the issue, okay, so we have to erase this from the website. So I was communicating to the website, and then they were saying, okay, we are non-publishing this or unpublishing, but non-publishing doesn't mean deletion. How do I go up there? I just want to illustrate with this banal thing that we do need to go more and more to technology, and this pressure of not understanding is there, what I already mentioned. But okay, let's move to the next one, which actually will touch upon what do we actually need. You asked about the conditions, and I really like that we have using the same keywords, independence and no conflict of interest and so on and so forth, and strategic advisor. So these are basically what I would like to just emphasize as well here. So I think that there are three main issues that organizations need to provide us. A little bit maybe abstract, but in a way, yes, safeguarding our independence, giving us resources, and giving us this authority, so kind of like a bit of more power. I think they are all self-explanatory, but just to re-emphasize this notion of strategic advisor, and I would like to bring the example that if I am head of IT or head of HR, not even head, but within those, embedded in those units or departments, then I do think that there is a conflict of interest. That is a no-go. That is really a red flag. So I need to be somewhere, and that's maybe the practical side. I need to be somewhere where I can somehow have this direct line to not a telephone like in the socialist era. I grew up there where you actually had to call on a separate line that couldn't be tapped. But okay, look, I think that it is important that in the ES I am under the Secretary General. I do have this possibility to write a quick mail, and the Secretary General answers to me directly, and I can flag things. So yes, then the actual answer is to be a strategic advisor, but an advisor, not somebody built in somewhere where, and then my vision is a little bit blurred. So I think that's the key message. Resources, I put the 3 T's: time, training, and team. And what I would like to mention here, and I came up with these 3 T's myself, and not by AI looking up what to say today, although I did check a few information. So look, time, obviously, so dedicated resources, training, it's clear. The biggest challenge is the team. Obviously, there is no money to have another person who is in my team than only dealing with AI or cybersecurity or whatever digital act. What I would like to share with you as a practical solution or pragmatic problem solver attitude, that we need to have these liaison officers like my data protection coordinators network, but also not even the DPCs themselves, because they already have the head that we have to be aware of data protection processing activities, but those liaison officers who might be just involved in, only AI technology, only cybersecurity, only IT. But I have a direct line to them. Let's say I can call and say, explain this to me. Tell me what it is. You are my contact person. You let me know, you educate me, and I will give my independent advice after that. And please accept this. If you don't, we heard it at the last panel, sometimes it's not always the case, but nevertheless, it is something important. So, and the last one was authority. So to have this a bit of a power, so to have the support of the highest management level as we have the in the regulation. And the last thing is balancing this. So in new responsibility with our core privacy mandate. So really last word, because I feel that this is quite important. We have a bit of an erosion, or I couldn't put it otherwise, of our task. So meaning is the fundamental rights protection, so our data protection mandate, is it somehow eroding? Is it somehow in the background because we don't have time to deal with it, because we are in the AI working group, because we are giving advice to the cybersecurity experts when there is a data breach, and we have so many with all the hacking. And this is what we need to be aware that, yeah, my primary role is to protect fundamental rights. I'm so grateful to have Merit as well, because Germany was with the first data protection law from 1970. I think Hessen, not your federation, but nevertheless, I think it's really something that we have to be aware that, we have to be there for our data subjects. If there is a request, then we try to reply and juggle with all this. I use the expression jungle, so we are in a kind of a digital jungle now. So let's stop here. And
Thank you very much for all your explanations and your practical experience about all things. But now we have just two last questions to our DPS representatives. We have to be really quick, but they are really important questions. First of all, to Daniele about all this new debate about the concept of personal data that worries so much to all DPOs. Well, just I know.
good luck.
I mean, I am asking to you to be quick in such a, but just a direct question about that.
Yeah, no, I will.
For DPOs.
I'll try to give 3 sentences about
Thank
that.
you.
3 sentences. The first sentence is that everybody expects sometimes, and I will oversimplify in these 3 sentences, but everybody, companies out there, sometimes also DPOs, in your practice, you expect that you should have a bit of a binary choice, personal data, non-personal data, because that's what you have to choose. You are asked, am I dealing with personal data, GDPR monster behind you, or not? Do not expect a check-the-box exercise. It will never be. But at the same time, I think with the case law we have the tools to determine when data is personal or not. I'm not saying it's easy, but I'm saying you have these tools, and as a specialist, you can advise about when you are dealing with personal data or not. What second sentence flashes from the not so recent anymore EDPS versus SRB case. It has been received in a very mixed way. There is still people that say there is a lot of confusion. The Commission seemed to feel like something more was needed when it proposed the amendment in the Digital Omnibus. I think if we stick to the case, the court gave us clear messages. And the clear messages are, even to the EDPS, who was, I will know, have no problems to comment on that, was probably too much on the absolute side of the notion of personal data. But the court has said, don't worry, personal data is not everywhere. As some people have said, the GDPR is not the law of everything, and you have to place yourself in a specific perspective, in a specific context. So your role as DPO is to identify what is the relevant context and assess whether the data is personal in that context. Maybe easier said than done, but I think with your experience, if you put together also the previous line of case law, you really have the tools to advise in an individual case. Last sentence, the court has gone into what we call a relative notion, which is this idea of you have to take a perspective, you cannot adopt what I used to call the NSA test. So if the National Security Agency of the United States is capable of identifying with this information, then the data is personal. Well, that's not the test that companies and institutions need to apply. True. At the same time, the court has been careful, especially with the references to the Scania ruling. You have to make sure that the risk of identification is not insignificant before you can say, oh, this data is not personal. Again, it will depend a lot on the context. I think that a reasonable application of this case law now allow DPO and companies to determine, in the vast majority of cases, I'm not saying in all cases, but in the vast majority of cases, to determine whether you are dealing with personal data or not with a sufficient confidence, with a sufficient certainty. I'm saying sufficient. If you want 100% certainty on this field, well, probably we will not get it, but because there is an intrinsic limit in the GDPR, which is it must be horizontal legislation. It must cope with the fundamental right in a variety of situations that happens in the wide world. And therefore, your role in calling in the individual circumstances is fundamental. but you have guidance. And I'd be happy to hear feedback also from the room if we have time.
2 seconds.
But I kept it
Yes,
to
so
really 3
I will-
minutes. Huh?
That was perfect. You were very concise. Thank you very much with the sentences. And just for Marit, about securization is, so now with all these new rapid technologies, is difficult as well. So securization. So could you give us some examples on how these data sharing obligations that, I mean, we didn't talk about European Data Spaces, Data Act, and so can be implemented in a manner that ensures compliance with data protection standards, ideally so through a by design approach?
Okay, so data sharing, I think it means we need to be even more professional than before. So we is meaning everybody who is processing personal data or data at all. There are many more obligations even if the data is not personal data. And in principle, it means to be aware of what are your obligations, are there exceptions, and discuss again with all the responsible parties. There are some technical and organizational measures, of course, encryption, access controls, look into the data space law and so. And we need, I think, more codes of conduct in this area. And therefore, I'm a little bit afraid because we have so little, at least in Germany, it's ordinary little, very, very, very few codes of conduct on data processing because of the GDPR. And we need that now also for the data sharing law. And perhaps one optimistic sentence, security can be your friend. It's not always, but very often it's. Security by design will be a standard. In December 27, the Cyber Resilience Act was not on the slide, will in principle guarantee that security by design is there and it has to be documented. Use those gifts. Look into technical documentation, ask for that. It will help you or facilitate the accountability at the first time in history. Of course, I'm a little bit too optimistic, but use the possibility, security by design, and then we have much as foundation. We need a little bit more, of course, data protection, fundamental rights by design, but it's possible. Thank you.
Thank you very much for your advice, and just we can prepare for this security by design obligations and requirements. Thank you very much. And so just we have some minutes left for the audience. Some of you may ask some questions to our panelists, please. Is your moment? Yes. Thank you very much. Yes.
Yes, I am from South America, and I was thinking that perhaps in your slide there is still another duty, that is to comply not only with EU regulations, but to comply with foreign regulations on data. So to give a bit more stress to DPOs duties, that may be another angle. So I would like you to comment on that.
Thank you, Ms.
Yes, since it was my slide, so I take responsibility or ownership. Yeah, I have long hair, so you can see that. Look, yes, the international landscape, legal landscape is something that we need to be aware, but it is relatively, when I use the word juggle with all the balls in the air, already with the EU acts is not easy. At the same time, in the DPO network, where I am also participating, and I'm leading chairing two working groups. One is AI, and the other one is international transfers. So the whole chapter 5 of the GDPR is there for us as a nice present. Yeah, I think nowadays it is something that it's unavoidable. Just because also, everything is now in the cloud or somehow with service providers. Of course, we in EU institutions try to have a lot still on premise. But nevertheless, yeah, it's not an easy question. So with Microsoft, Amazon, and all with the data hacking. Of course, this whole issue of whether data was actually spreading around the globe and over the ocean is something that we need to be, I use the expression top of the file. I will not drag on this, but just to make, so the California data, but I mean, all the acts of, especially US now, I know that maybe not friend, I mean, yeah, these are difficult questions. I think you just wanted to raise and provoke. I will not have a problem solver, I mean, a quick button to solve this. But I think in a way it's not that difficult. We just have to comply to our rules in a way, because I always say that, you know, you basically, if this is the case, when you transfer the data, that's when you need to be actually be compliant. And for that, you have the GDPR, we have the UDPR. When you receive the data from the other side of the ocean, then it's just to take care that we securely store, we securely treat, handle. So that's my simple answer.
Thank you very much, Mese. Thank you. I don't know if there is another questions. Thank you very much.
Thank you. My name is Ricardo Catalan. I'm not from Catalonia, but I work for the Dutch DPA. My question is regarding the conflict of interest. You've discussed a lot about it, but one factor that is not taken into account, in my opinion, in this panel, is that the DPO also has an ombudsman role. The DPO should always be accessible for data subjects, and that implies the ombudsman role. Now, I heard a lot about problem solver, bridger, enabler, etc., but you have to take into account that when you talk to a data subject, the data subject will come to you and say, is this correct? And your answer cannot be, I, the DPO, think that I, the enabler, did a good job. So you have to keep in mind always, what am I going to say to a data subject? Or when I report to the highest management, when you say, well, the way we implemented that, it was really well because I did it myself. So you have to have a separation that's beyond the judicial verdict that was given on just the means and purpose, and to transform this into a question. What's your view on that?
Daniela Marit, please.
I can give one answer,
Okay.
not one sentence advice, but yeah, I understand your ombudsman role question. I sometimes feel that as a DPO, you are a lawyer in the sense of a solicitor, barrister, and judge at the same time. Of course, we are not judging, because if we were judging, then we would be not independent either. So yeah, we try to balance this role as well. Very difficult. Yeah, I have a few complaint cases, unfortunately more and more, but I think it is not because there have not been before, it's just that we are more known through our awareness raising activities. So it's very, very, very difficult. And people, I mean, we are people. I had one more slide that I didn't want to show that is visualizing me, I mean, not me, but the DPO function, and I am putting a little figure, a bonhomme, because we are also humans. So yeah, to give you an answer, I think that only the independence, let's say, requirement could work. That we try to understand what the data subject complain about, and not to blur our vision somehow. But this is it's something like, you know, our dignity or integrity in our job. So there is no good answer. It's just that, and you might not be even criticized if your judgment was not even correct. But somehow, yeah, you give your best shot and try to survive.
Yes, so difficult, Mesa. Perhaps we could have DPS perspectives about that.
Yeah,
or?
I
Thank you very
see
much.
the problem you're facing. If I were your DPA advising you, I would say, yes, you have to solve problems, you not have to solve every problem. And that's why DPAs exist, meaning that if you receive a request in this capacity as an ombudsman, and you propose to your hierarchy, I would like to answer this, or there is a problem, let's fix it so I can address this person. And then you see what they tell you, because in the end, DPOs have a functional independence, which is not an absolute independence. So your role is to be independent vis-a-vis the hierarchy. That's why there are special reporting lines provided, but it's not an absolute independence. And that's why the independence of data protection authorities is a bit of a different nature. It's a different ballgame, if you let me this term. And you can go as far as you can, but indeed, that does not mean that alone you will be able to solve all problems of the data subject dealing with your organization.
So problem solving sounds as if it's already the operation. You should do that, you should decide. And I think in the panel it was also clear, they are not the decision makers, they are not those who are really doing the work, but giving advice internally first on risks, having reports so that all risks or all different perceptions, perspectives are on the table of the data controller, and then the data controller itself will decide. So problem solving, I think it's more the being constructive, listening, learning about alternatives, something like that, and not solving the problems on your own. It's not on your shoulders.
The external ones, at least. The one involving,
They want to. Okay, they sell different services. Okay, then of course external, internal may be also a difficulty there. Yeah.
Thank you very much. I think we are out of time, but if there is a last question in the public, a very you quick one. Yes, very quick. Thank you. Thank you, Joanna.
Thank you. I'm Francis Young. I'm working with the Dutch Ministry as a privacy advisor, and I'm very interested in the difference between the risk analysis, the DPA, of the DPA from GDPR, and risk analysis that are necessary on behalf of the AI Act. Because I have a certain view that they have to be done separately, but I hear there are different opinions on this topic. So, from the DPA side, what is your expert opinion about this analysis?
You won.
Yes, we are working, as I already mentioned, we are working hard in this group, within this group, because when we began this work, we thought, and Joanna could complement me here, these exercises were more.
Oh, now it works.
Okay, were more a duplicated exercise that actually, when we went in detail, we have a different perspectives, and I explain myself. When you are dealing with a data protection impact assessment, you are dealing with a processing activity. When you are dealing with a fundamental right impact assessment in the Article 27, you are dealing with an AI system, which is regarding GDPR, is a mean of the processing, which is very focused. You are focusing your fundamental rights in one tool, in one AI tool. And then you are going to your data protection impact assessment, which is, for me, is broader. For me, it's broader. If you are dealing with methodologies in data protection that look into all the fundamental rights, not only in data protection, I would say that we are all doing fundamental rights assessment in processing activities. And now, regarding Article 27, you will be doing fundamental rights impact assessment, focusing in a tool, in the AI tool. I mean, I think you can combine the results and you can enrich a lot because you focus and you go into the details and damages you can create to the subjects. For me, it's enriching. It's very enriching, but it's complex, and I think we all need a methodology, a tool. I don't know what, in order to make this simple. Because if not, in business, it's hard because you have to make too many questions to the business, to technology, to security, and so on. And I stop here, and if you want, we can continue in the lunch. And
Thank you very much.
And still, the responsibility for conducting a DPIA is with the controller again. So the DPO is giving advice. He or she should be asked for that. And it's good to have a structured way that you don't miss anything. And therefore, the DPOs, again, are in a very good position. For AI, there might be additional risk. I think that still, in the beginning, all the fundamental rights are already in Article 35, okay. But still, like, what about climate, energy consumption, something like that? We're not so much skilled in that. This might be a thing for the fundamental rights in the AI system area, because there have to be some criteria and parameters anyway. So there might be additional people or perspectives to be involved. But still, again, who is responsible, the controller or then the provider for the AI system? And therefore, it's good to ask to get the knowledge from the way where it is, and it's good to have a thinking in kind of modules that it's compliant, that it's clear you're talking the same things, it's compatible, you can reuse or make use of what is already there. Thank you.
Thank you very much. So I think now we are already exhausted from time, so I really want to thank to all the four speakers for this rich debate that we had today, and for sharing with us all your knowledge, expertise, and experience. Thank you very much to all of you.
Thank you, Olga.